Good day, everyone. I'm Bill Kovacic. I'm on the faculty at the Law School at George Washington University, and I'm thrilled to welcome you to the third of our hot tub discussions. This one on antitrust and sustainability, part of the solution or part of the problem. This is the third in the series convened by the ABA section of antitrust law and inspired by Fiona Schaefer, who is part of the leadership team of the section. And in these discussions, we've sought to provide a forum for informed discussion on issues emerging in the often tumultuous discussions about the future of US competition law. Our two previous sessions focused first on the goals of the US system, second on the application of the goals framework to merger review, and today we're going to take a look at a major emerging area of the intersection of competition law and another policy domain, that being environmental policy. And our concern today is with sustainability, which in a number of popular accounts and scientific discussions is a matter of great urgency, maybe even more important than competition law itself. Indeed, the concern is that there is a window of opportunity now to develop solutions to a variety of environmental policy concerns, and that window will close unless there is a broad-based effort that reaches across a number of policy domains to develop solutions, and that competition law and policy has to be part of that conversation. In many respects, this issue has been at the top of the discussion in many policy debates in Europe, and I sense is making its way across the Atlantic to the US, which is why we're engaging today a set of great specialists in the debate in the European Union and bringing it over to the United States as well. We've got some superb academic commentators today, and we'll be led initially by Simon Holmes, who's a visiting professor at Oxford University and a member of the United Kingdom's Competition and Appeals Tribunal. We have three practitioners. We've got Dirk Middelschulte with Unilever. We've got Dominique Alepin from Nike and Helen Jenkins with the consulting firm of Oxera. And we have, in addition to Simon, another public official, that's Sauter, who's with the Authority for Competition and Markets in the Netherlands, an agency that has played such a formative role in developing initial policy approaches to bring these two fields together. Our format today is going to be to have our panelists each give an initial framing comment. We'll be led off by Simon, and then we will proceed with our other panelists. And then we're going to have a discussion that focuses on in many ways, on the subjects that have been raised in the initial comments. And we'll have an opportunity to take your comments and questions through the chat, please. And to kick this off, Simon, let me thank you again for your great generosity and willingness to do this. You've played such a formative role in the debate, and you've helped guide us in the formulation of our session today. If you could please start us out.
Thanks, Bill. Well, to set the scene, I thought I'd just give a personal indication of how I came to be so involved with this area. I spent 35 years as an advisor, as a business advisor, advising on competition law. And towards the end of my period there, I became increasingly concerned about the tension between my concerns about climate change and the work I was doing on things like recycling, and my core role as a competition lawyer. Competition, which I favor, I would add, and I'm not turned against competition or competition law. Competition, though, the process of it drives consumption and drives us to use ever more of the Earth's resources. It also, even against the will often of businesses, the process of competition forces companies to look for cheaper inputs. So whilst the competition may drive more innovative products, it also leads to a certain race to the bottom, the need for cheaper inputs, which are often less sustainable. So I spent the last 2 or 3 years writing, thinking about and speaking about how we can take account of sustainability and climate change in a modern antitrust policy. And I think one of the things that the ABA has kindly circulated is a one-pager with some of the papers I've written on this. As Bill mentioned, this is now one of the hottest topics. It was an obscure topic a few years ago when I was looking at it, but now I'd say it's one of the 2 hottest topics, the other being the digital agenda. Before we move to our core area, though, I would emphasize that this sustainability is relevant to all areas of antitrust law. And therefore, I would add as an aside, there are opportunities for law firms both to play their part and, I would suggest, financially. The core area which we're looking at is where businesses need to cooperate on sustainability issues. So that potentially invokes Section 1 of the Sherman Act, Article 101 of the EU treaties, and our national equivalents. But just so we don't leave it out completely today, it can also be relevant to the control of monopoly power, Section 2 of the Sherman Act, or the abuse of dominance provisions in Article 102 of the EU treaties and their national equivalents, in two respects. First, as a sword to attack unfair, abusive, unsustainable practices, where appropriate. Secondly, something which might, but on first superficial analysis, look abusive when done by a dominant player, might, on analysis, be perfectly acceptable, where the objective is something to promote more sustainable products. And finally, in mergers, and I don't want to overstate this, sustainability can be, as a factor of quality and so forth, a positive factor, potentially leading to the clearance of a merger, and as a negative factor as part of the analysis of whether a deal should be allowed or require remedies. But moving to the main concern, we face, and I say this, never say this lightly, an existential crisis with climate change. And as Commissioner Vestager has said, everyone's called upon to make our contribution to the necessary change, including, she emphasizes, competition enforcers, antitrust agencies, and I would add, business and their legal and economic advisors. Of course, regulation is often the best solution. In an ideal world, we'd have regulation that dealt with all these issues, but it's not always enough. It's slow, limited in scope, and not ambitious enough. Look at COP26, or rather, look at what didn't happen at COP26. I often feel that we should stop quarreling over which policy tool is the best. We need all these tools, and we need them all now. I'm not sure if it's been circulated, but I my frustration at the arcane discussions in conferences about weird antitrust concepts whilst the world heats up and the world floods. There's a little cartoon that I hope has been provided or will be provided to you. And of course, businesses can and should compete on sustainability to produce more sustainable products. But sometimes if they do that, they'll suffer what we call a first mover disadvantages. Sometimes, not always, short term at least, more sustainable products can be more expensive. So it's not viable. But even where it is viable, it's no good if a few wealthy lawyers and economists buy the products, and that represents 1% of the market, when we need to transform whole sectors of our economy onto a more sustainable basis. And there again, cooperation may be necessary to achieve the necessary scale and learning. And that, of course, is where antitrust law comes in. A survey by Linklaters suggested that some 60% of businesses had shied away of cooperating in this area for fear of competition law. Now, I've hopefully circulated some examples from my own experience of fear of competition law, but I know I won't elaborate on those now because I know Dirk and I think Dominique will be giving some examples from their experience. But these are real life examples where something which you'd say was inherently good that we want as a society to see done was inhibited by antitrust law, rightly or wrongly. And I would emphasize finally on this comment that we're not talking about greenwashing. If people collude and decide not to compete on environmental criteria, that's a cartel like anything else. The AdBlue case in Europe illustrates that. I think greenwashing is a real concern, but I think it's essentially a consumer law problem. And I know Helen will be saying some more about greenwashing later, so I won't say anything more. The prime thesis of a lot of my work is that we already have the relevant legal tools. For example, I've written about what I call the EU law's constitutional provisions. Those are the bits at the beginning of the treaties, which amongst other things say that environmental protection must be integrated into all union policies and activities, and there's no get out for antitrust law. But having written about that, I've concluded, particularly when I started to look at other jurisdictions like the UK, where we can't rely on the EU provisions, sadly anymore, it's the actual competition law provisions themselves that give us most of the answers. And I've suggested, I've analysed it with 5 different ways in which a cooperation agreement to fight climate change or otherwise might fall outside our Article 101 completely, standardization agreements being an obvious example. Again, not pretending to have any expertise, but I'm well aware that the US Supreme Court has made it clear that not every restraint of trade is caught by Section 1 of the Sherman Act. Business couldn't function otherwise. But many agreements will be caught by the prima facie prohibition on anti-competitive agreements, and that's where an exemption may be required. Article 101(3) under EU law, all 4 conditions for that must be met. And there are numerous areas of controversy. And in these introductory remarks, I can't really go into those. I'll just flag a couple of them. But what about US law? Now, I have absolutely no pretense to know very much about US antitrust law, but at risk of it sounding like a complete amateur, I'd make 3 observations. One, in my view, and this is speaking very generally after many years of practice, antitrust laws and competition laws pursue very similar goals around the world. Secondly, they've proved themselves to be remarkably flexible over the decades. And thirdly, if they're not flexible, and if they don't continue to be flexible, if they're too arcane or remote from society's priorities, they'll risk being seen as irrelevant, and other policies, other things will take their place. So then I mentioned there are areas of controversy. A couple of years ago, I used to say a lot about the first condition for an exemption under EU law. This is that an agreement must contribute to improving the production or distribution of goods or to promote technology or economic progress. Pleased to say, I don't think that's controversial. It's pretty obvious. If you have an agreement, sustainability agreement, which ends up producing more sustainable products, using more sustainable imports, cleaner air, etc., and so forth, that is an improvement of that sort. It's economic progress, it's technical progress, and so forth. Not really controversial now here in Europe. What is controversial is exactly the second condition, is that consumers must get a fair share of the benefits. That is a controversial area. I'm happy to discuss it in questions. I think Wolf will be saying something about that. And the third one I just comment on is that the agreement must be no more restrictive than necessary. And I am a strong advocate of that when I take a robust view of the benefits of sustainability agreements. If something could be done by other means, by regulation or by competing, then that should be done. But let's not misunderstand that. Just as I said earlier, just because by competing, you end up with some niche little expensive products representing a tiny proportion of the market, it doesn't mean to say a cooperation agreement is more restrictive than necessary if in fact it's going to lead to a transformation of whole sectors of the economy. Or similarly, if you've got legislation in place, but business is prepared to go further or faster than that legislation, again, the cooperation may be necessary. So where have we got to? Industry has stepped up to the plate. More and more companies are getting involved with this. The presence of the companies here, we have Nike and Unilever here, prime examples of that. I know Dirk, who will be speaking shortly, his company has put forward a lot of constructive examples of the need for cooperation to the Commission. International bodies like the International Chamber of Commerce is involved. I'm pleased to co-chair the task force on sustainability and competition policy there. We're putting forward papers to the relevant authorities. International bodies like the OECD, we've had two conferences on roundtables on sustainability and competition policy. And then there's, of course, the competition authorities. The Dutch, I would say, the leaders of the pack. No more to say on that because we have Wolf here from them. Countries like Austria have actually changed their law to make it easier to exempt sustainability agreements. And then, of course, most important, I would say, at the moment is the European Commission. They've been looking at this in the context of the Green Deal and the revision of their horizontal guidelines. Most recently, most people, I should suspect, on this panel commented on their draft guidelines, and we await the amended guidelines. And then there's the US, again, the area where I'm not qualified to comment, but I'll make one comment nevertheless. I hope and believe that we are seeing some signs, for example, in Jonathan Cantor's speeches, of the US moving away from some of the more doctrinal approaches and the emergence of a broader policy objectives behind US antitrust, perhaps going back to more of its original intentions. And in this light, I would commend papers by people like Amelia Miazard, pro-social antitrust. And finally, not least, there are the law firms. The law firms are also getting involved for whatever reasons, commercial, and I believe very much because they want to play their part in the necessary transformation. And interestingly, when I looked at my personal mental list of law firms, many of them were American. I've been working a lot, for example, with people from Cleary Gottlieb and Baker and McKenzie. So in conclusion, whilst in my work I've suggested some changes to the law, in the big picture, those are minor. I think we have already the legal tools, but we need to revisit and rethink about how we actually use them. And final comment, there is a role for lawyers to help clients navigate through this. My plea to lawyers is to give more robust, less timid advice, and also to help clients bring forward practical examples to the authorities, not only so that they can get guidance in relation to the particular initiatives that they want to pursue, but also so that the authorities in turn have the knowledge and the courage to give better, more general guidance. And on that, I'll pass back to Bill.
Simon, thank you for getting us off to such a great start. That's a wonderful frame through which we can look at the issues that we're going to see in much more detail. As Simon said, we're going to turn now to Dirk at Unilever. Dirk has had an opportunity to get a sense of where perhaps existing applications of competition law might discourage desirable forms of collaboration. And Dirk, if you can take us through some of your observations based on your own recent experience about where competition law might get in the way, and as Simon was suggesting, how a non-timid, more robust form of counseling might provide solutions. Dirk, please.
Thanks very much, and a big thanks to Bill Kovacic and the section for having me today, inviting me to join this session. I had the privilege to also contribute to a publication of the section last year on the very topic of competition law and sustainability, which not because of my contribution, but because I think overall it gives a good overview of the issues at stake. I recommend for further reading for those who are not yet familiar with that piece. And it touches also very nicely on the European developments, though the most recent ones, of course, were not yet covered. So I think Simon very nicely set the scene also for me in particular, because I can now build on what he said and dig a little bit deeper on some specific points. And I also need to make the caveat that my understanding and comprehension of US antitrust law is also very limited. So I probably follow Simon's reading of the law, that ultimately the objectives are similar and antitrust laws have been very flexible. So that I believe what we have been thinking about and discussing in Europe may apply in a similar fashion in the US. And if I sometimes refer to Article 101, because I'm just too familiar to using the technical language, this is essentially the equivalent of Article 1, or Section 1 of the Sherman Act, about restrictions between undertakings. I would like to start with the question that is often asked: so where is competition law relevant in this space and in the sustainability discussion? And I think it is a complementary tool. Let's say cooperation is a complementary tool in achieving sustainability objectives, and that we have regulation, which is very often desirable, also from the perspective of companies, which is sometimes, I think, underestimated, especially outside the business community. Regulation creates a level playing field. If it's smart, it's very desirable. And there are also companies doing their own fair share of sustainable innovations and sustainable products in order to attract customers. Because yes, consumers in our industry in particular want more sustainable products and do therefore request such products, so that we, for instance, are more successful with our so-called sustainable living brands than other brands. So brands that have specific sustainability credentials. And when you go to a supermarket or when you buy another consumer product, you will see that sustainability is an important part of the offerings of the companies, and will become so even more so. So what's the problem? I think the issue that we're facing is that sometimes we are having regulation that's insufficient, that's not effective, because it's just a political compromise. Sometimes you have environmental agencies that are limited in their powers, as we have seen very recently in the US. In Europe, we have the issue, like everywhere in the world, that many stakeholders need to agree on regulation. And regulation is not always fast enough to respond to emerging industry trends. In terms of what the markets can deliver, we have the issue of what is often referred to as the first mover disadvantage. When you have a really game-changing innovation where you introduce a sustainable product that may land with consumers, but it may not, because the costs are prohibitive and consumers will not switch to that product. And we've seen this happen in very simple examples when we compacted products that delivered the same performance, but consumers were assuming that a smaller product is not as performing as a bigger one, and therefore refrain from buying it, even though the environmental footprint would have been much more beneficial. And so the phenomenon that I've been trying to describe is something that the Commission now calls residual market failure, which essentially means the markets cannot alone deliver it, and regulation also does not resolve the issue. So that we have residual market failure that the Commission also, by the way, also outside the environmental space, responds to with state aids, or let's say state aid law that permits state subsidies to a certain extent. And I think competition law also has a role to play here, as, by the way, now also acknowledged by the European Commission in its draft horizontal guidelines, so the draft guidelines that govern the relationship between competitors and provide the Commission's interpretation of Article 101 in that respect. So what are the reasons for the difficulties of individual action? I think I touched on it already. First mover disadvantages, the prohibitive costs. And I can maybe provide a few examples where this comes into play. Some of them hypothetical, and there are instances where I know companies are looking into collaboration already, connecting with the European Commission, for instance. We also have one case, but I can maybe not talk about details given the confidentiality of the projects. But to give you a little bit of an idea, a big issue in our industry is plastics, as you will imagine. By the way, also to meet regulatory targets, because we increasingly have plastic tax introduced in Europe that require consumer goods companies to reduce the share of plastics in their products. And that requires us to source more recycled plastics, because they would then qualify as good plastics and admissible under the tax regulations. But the availability of recycled plastics is limited, so that joint procurement, massive joint procurement, may be an answer in order to incite recyclers to create more capacities for recycled plastics that are currently lacking. And similarly, more on a standardization level, a big issue when it comes to the recyclability of products is the problem that companies are using different inputs and different types of plastics that make it hard to recycle them, so that a harmonization of packaging inputs would be helpful in order to drive this through, for instance, mandatory standardization, which is something that, at least under European law, is difficult to justify before the antitrust authorities. You could also think of an example that a colleague of ours, Maurice Dormans, always refers to, where airlines agree to accelerate the introduction of more fuel efficient aircraft and green fuels. Or similarly, in the car industry, let's assume car manufacturers were to agree to replace combustion engines not by 2035, as currently envisioned in Europe, but by 2030, which will probably come with additional costs. Individual moves like that may work out, but they may not, because the costs may be, again, too prohibitive. And also, you wouldn't have the impact of a broad industry coalition introducing the new technology effectively on the market. Similarly, let's take cars again. I'm German, so I can sort of make fun of the German car industry that I admire for its technical ingenuity. But if they were to agree that they are not producing, and I'm taking a very simplified example, that not everybody will like, and not everybody will like the idea that they reduce the maximum size of SUVs. So why not agree to reduce the size of cars that can be brought to market? Quite a drastic intervention that companies could think of, and I'm putting it out here maybe as a topic to be discussed, where certainly individual action might be a bit more difficult to justify before shareholders and the boards, but collective action might be feasible. And the question is, of course, does competition law provide the right answers? And since my time is almost up, I would probably then skip my legal reflections that I'm happy to provide at a later stage, but would like to put out one point that I think is important, and I imagine that Dominique will also pick up on this. So what we hear from the European Commission and other enforcers is that why don't you bring us all those cases? So if this is such a big issue, you should have millions of cases and you should flood us with them. The thing is, there are cases increasingly, and the Dutch authority has been dealing with some of them. But I think we're also going through a development where we will have a number of important cases in the near future, and companies are in the process of realizing that they need more collaboration. And the reason for this are pledges and commitments and targets that companies set, very often voluntarily, but also because there's increasing pressure and maybe even legislative pressure to set targets in terms of carbon reductions in particular, or reducing plastics and whatnot. So these targets are increasingly legally required, and of course also by consumers, NGOs, etc. And secondly, not missing the targets becomes a big problem. While in the past, you would just be silent about having missed a target and set a new one. In the future, you might be facing increased pressure from the consumer groups, but also potential litigation and other consequences driven, for instance, by the SEC in the US. And that maybe is a good point for me to stop and pause, because I'm not the expert in that space, and leave it to the American presenters to touch maybe on the sort of the link between competition law and other regulatory requirements that we see in the ESG space when it comes to sustainability objectives. Thank you.
It's a wonderful, wonderful collection of examples, and just a fantastic practical perspective. If I could ask for a moment, when you look at, say, the Article 101.3 framework that Simon referred to before, which is well known to practitioners, of course, of competition law, I think really in the United States and in Europe, what part of that framework gives you the most anxiety? That is, on its face, it would seem to be receptive to exactly the kinds of considerations that you've been referring to. In what respect, if you can mention one, and we can come back to this, especially with Dominique in the US perspective, what aspect of it causes you the most anxiety?
I like that question, because the letter of the law doesn't cause any anxiety. The law talks about benefits that consumers need to get a fair share of.
Yeah.
The issue that we have been seeing in Europe is, and I know that Simon likes to allude to it, is that benefits has often been translated with efficiencies in the sense of economic efficiencies, like reduced prices, more output, more innovation and quality. And I mean, all of these elements can materialize, of course, when it comes to sustainability corporations. Those are the non-problematic ones. To be sure, there are many cooperation scenarios where you wouldn't be facing issues in the first place. I'm sure that Wolf will talk to that. But benefits is, in my reading, to be understood much broader, also before the context of the European treaties, but you don't need the European treaties for this. You can say a benefit is also the reduction of carbon emissions, or more technically speaking, the reduction of negative externalities, which is a benefit that you can quantify, and Helen will probably talk to that. And so I'm not concerned about the letter of the law, but of the reading that has been applied by authorities and legal practitioners in the past. And the second element is the fair share that needs to be attributed to the consumer. So they need to receive their fair share. Unfortunately, this is very often been read as full share, i.e. if consumers pay a higher price, which is the restriction of competition, or have less choice, in my slightly provocative SUV example, they need to be compensated. And I think there is a compensation in that there will be less carbon emissions, but they may not individually be fully compensated for this, because the benefit that accrues to them may be relatively small. So why not have a reading of benefits as collective benefits, so that the fair share criteria would be met if they only get a certain part of the benefits. So that, in a nutshell, are my main concerns in that respect.
Yeah, Dirk, thank you. And that's again for our North American audience. I'm grateful for your teasing out the different elements that would have to be established, as Simon did earlier, in order to establish the justification needed under the 101 framework, the Section 1, the rough equivalent to Section 1. We're going to turn now to our Our colleague from the ASEAN in the Netherlands, as Simon mentioned earlier, the ASEAN with Martijn Snoep, the chair of the agency, has played a leading role in bringing these issues to the front of the debate, has been using some of its own capability and policy guidance to advance the policy discussion. Wolf, if I can turn to you, so much of the challenge in policymaking is crossing that distance between the aspiration and its realization in practice, day in and day out. You're in that realization domain. Can you give us some thoughts about what you've been doing and what issues have come up as you've been doing it, please?
Thank you, Bill, also for the invitation to speak here today. I'm going to speak on guidance on sustainability agreements from the Dutch perspective. So I'm going to explain why we give guidance and how it works. Over the past 2 years, the Dutch and the European Commission have issued draft guidelines on the application of competition rules to sustainability agreements. We got there first, and in January of last year, we distinguished a separate category of environmental damage agreements, where we came up with a new approach to the consumer's fair share of the benefits that I'll mention a bit more later on. The EU in March of this year came up with a sustainability chapter in its draft revised horizontal guidelines that's to be finalized by the end of the year, as has already been mentioned. And we will have to eventually adjust our own approach to that of the Commission, but the debate on the substance of the Commission's guidelines is still ongoing. So they haven't finalized them yet, and we're still trying to influence that. In the meantime, we're already providing informal guidance in concrete cases, of which I'll mention a few. I'll just start with the Dutch context. Any responsible government has to take timely and effective measures on climate change, I believe. And the Dutch have particular reasons to do that, because in 2019, the Dutch Supreme Court found the Dutch government liable under tort law for a failure to meet its climate obligations in the agenda ruling, which led to a climate accord and a climate act in 2019 to reduce greenhouse gases emissions in successive steps of 25% by 2020 and 50% by 2030. And at the same time, the Dutch social model relies on sectoral initiatives and self-regulation to attain sustainability goals. And that's why we need guidance, because essentially we want to be able to rely on business to a large extent. It's doubtful if centralized governmental command and control is timely and effective in any event. Polycentric solutions effectuated by those directly involved seem to be necessary, and I personally believe that problems should be solved at the lowest effective level. And all this points in the same direction. And that means we need agreements between firms to address negative externalities and first mover disadvantages. So sustainability agreements are necessary, but they may be hindered by the competition rules, as we've just heard. Firms may be hesitant or cautious. And to facilitate firms, the ACM provides informal guidance based on its draft guidelines. As a context, it may be useful to know, if you don't already, that the Dutch competition law is a carbon copy of EU competition law. But at the same time, we also apply the EU competition rules themselves to issues with a cross-border dimension. The assessment under the Dutch guidelines comes in two parts. The first part is that there is no restriction of competition if we're talking about non-binding agreements, codes of conduct, joint standards, and certification labels, or agreements to improve product quality where less sustainable products are no longer sold, and also agreements necessary for know-how or scale in innovation markets, or to ensure respect of standards set in law or international agreements. There would not normally think competition is being restricted. The second part of our guidance that's relevant is a specified interpretation of the 4 conditions for a legal exception to the cartel prohibition that, as I mentioned, is the same or highly similar in Dutch law as in EU law. There have to be net objective benefits. In the second place, there has to be a fair share for consumers, which is the contested condition. There can be no indispensable restrictions, and there should not be an elimination of competition. So most noteworthy, perhaps, is our approach to the second condition of a fair share for consumers, where we've come up with a special rule for environmental damage agreements. And there we think the polluter pays principle should apply, so that when we're talking about agreements that try to eliminate externalities and implement an international national standard or policy goal, such as the reduction of carbon emissions, then under the fair share conditions, the benefits for society as a whole should be taken into account. so also out-of-market benefits. And this potentially includes fully taking into account benefits in third countries as well. For other sustainability agreements, we have a different approach. There, I believe full compensation of consumers within the relevant market may be appropriate, as is the rule that the Commission tries to maintain. A final element that may be of interest is quantification. We think there doesn't need to be quantification if there's a market share, quantification of benefits, if there is a market share of less than 30%, or if there are order of magnitude benefits that allow us to rely on a qualitative assessment. And finally, we believe that quantification should go beyond willingness to pay, which is something the Commission focuses on, to include also environmental and shadow pricing. Finally, I'll make a few remarks about how our guidance is applied in practice. It's based on self-assessment of compatibility with the competition rules. That's the general rule that applied since modernization of EU competition law. Undertakings have to demonstrate their agreements meet the 4 legal requirements for the legal exception to the cartel prohibition. And there is no independent data collection by the ACM, so we rely fully on the information provided by the companies. Of course, we do ask around a little bit. We speak to our colleagues, we speak to the ministries, and we speak to the European Commission, but we don't do a full investigation. We then provide an informal view on possible risks, not an exemption. And if there are no major concerns, the undertakings can proceed, but they still do so at their own risk. However, that risk is limited because if the agreement is subsequently found to restrict competition, we are not going to impose fines. So if there was a bona fide provision of information to us and there was just an error on the assessment, then they are not going to be punished for that later on, as long as they adjust their agreements appropriately. We have issued a number of press releases, sometimes completely informal guidance in emails to companies, but we've by now published also a couple of no action letters that are available on our website. Over the past year, the business of giving guidance has taken off. Initially, companies were reluctant to step forward, but now increasingly they're doing so, so it's beginning to heat up a little bit. I can give some examples. Over the past year, we've seen a system of private sanctions to eliminate illegal pesticides in the gardening sector, the promotion of forest-friendly soy in the full product range of supermarkets, and replacing short passenger flights by train. But in the energy sector, I think we've seen the most significant developments. There's been the reduction of toxic fuels for export to West Africa. A lot of those are produced in Rotterdam. They're highly toxic. And about 90% of the fuels used in West Africa originate in Western Europe and are very dangerous and harmful. There's an agreement to engage in sustainability due diligence in renewable energy supply chains, so for wind energy and solar. We've seen the joint purchasing of large offshore wind energy by an association representing 50% of Dutch industry. Joint shadow pricing of carbon costs for energy network managers in electricity and gas distribution, and most recently, joint carbon capture and storage in depleted offshore gas fields and opening up related infrastructure by 2 oil majors. So I think this increased uptake demonstrates the demand for guidance on sustainability is growing, and every responsible competition authority should provide it. I was going to say something more about the technicalities of what the Commission has proposed, but I'm not going to. Maybe I will during the discussion. Instead, I'll just wrap up by concluding that if the competition rules are not part of the solution, they will remain part of the problem, and that is something we cannot afford. And with that, I would like to pass the floor back to Bill.
Oh, thanks, Wolf. That's again just a fascinating set of examples for us to consider in the effort by a leading authority in the European Union to develop an adaptive policy approach here. Could I ask for a moment, what kind of interaction do you have with the other regulatory authorities in the Netherlands that share responsibility for some of these policy domains? For example, the fuel example that you just mentioned in the energy sector. Is there an ongoing conversation taking place with your office, your colleagues, and those who in some sense might be called the environmental protection specialists and regulators?
Could you specify your question? asking me whether we're talking cross borders or cross ministries?
Just within the Netherlands itself. That is the interaction between the ACM and other regulatory authorities with environmental policy responsibilities.
That's a good question. We do have those conversations. Sometimes it's difficult because a lot of the material that we obtain is confidential at the time that we're dealing with it. So we have to be circumspect from time to time. The initiative with relation to the fuel in West Africa was actually an initiative taken by an inspectorate that wanted to impose this rule on companies for them no longer to be able to supply dangerous fuels to West Africa under a duty of care. And the companies were thinking that maybe they ought to form a cartel to regulate prices if they wanted to meet those demands. And we weighed in on that. So we do talk to inspectorates, for example. In other cases, we found that inspectorates are not fully equipped to address the concerns involved. I mentioned the gardening sector. It might seem a bit standard or not very interesting, but we've still found it interesting in that this is an agreement where the gardening retail sector is trying to impose a sanctioning system in order to ensure that legal standards are respected that are not currently being enforced by our inspectorates because they're understaffed and overburdened and they simply cannot handle their job load. So then we think that this is something where it's possible for companies to step in, even though it's below standard competition that they're dealing with. So we do talk to other parts of government, probably more than we do to competitors, and that could be a point of criticism.
If I could turn now to Helen. Helen, you've had a number of opportunities as a commentator, certainly in your own thinking about the work you're doing with the business enterprises on these issues, about how to measure harms and benefits, how to bring them into the calculus. If you give us your thoughts about your own scholarly experience as a commentator, but also in the practical advice about individual cases, please.
Thanks, Bill. So actually, building on Simon's intro, I was thinking that the first thing I did in the mid-90s when I joined Oxera while still completing my doctorate was about the economics of climate change. And the key things that we were talking about then was massive collective action problem. So good to start early and do it in a cooperative way through policy. That carbon taxes were an essential part of any solution, and that you can obviously value the benefits that accrue to citizens and non-users. And when you reflect on that and think where the debate is now, you realize that the politics of all of this is perhaps driven by that huge collective action problem, a lot harder than sometimes that which economic thinking might say, look, answer's simple, just internalize the externality, guys. So my initial comments, I'm going to cover three things. First, building on that idea of residual market failures that Dirk discussed, and the fact that there are these collective action problems, particularly for green and climate related topics, make it genuinely challenging to make progress just in the normal course of events. So, but I think there are some principal differences between policy-led and market-led solutions, and the role that competition policy, competition assessments should be playing in both of those. So then I'll move on to talking about there are good reasons why businesses want to cooperate, as we've heard already from Dirk in particular, but also from Wolf, from the two sides of the table. So businesses do want to cooperate to help with these challenges, but we do actually have to worry about greenwashing. And what we need to understand are the incentives on private sector businesses to coordinate, both the positive incentives and the perhaps harmful incentives to coordinate, so that we can differentiate between greenwashing and sustainable aims. And then third, once we've decided that a cooperation agreement has got legitimate drivers, in general, there's still going to be a need to quantify and balance the trade-offs, to look at the sustainable benefits and think about the effects on prices and choice. So then, we do have to think about those techniques. So I'll cover all three of those quickly in these introductory remarks. So when we think about what the issues we're concerned about, I do think that sometimes there's a confusion between two things. First of all is we say we have a big challenge in that we need to achieve a lot of behavior change in consumers and citizens. And we also need to introduce affordable new technology to help us meet our sustainability goals. And that's to the extent we have agreed sustainability objectives. And there, the goal is, how do we become more sustainable? And that's often a democratically agreed goal that has been decided, that the society wants to do that. Now, second, we have a proposed commercial cooperation with a sustainable objective. And we have to ask ourselves the question, is that indeed beneficial? How do we tell whether that company or those group of companies is undertaking a greenwashing endeavor to disguise an uncompetitive change, or are they indeed helping us save the planet? So under the first, when we're thinking about the policies and the drivers to achieve behavior or technology changes, you don't actually necessarily need a commercial rationale for those proposed changes, because in a sense it's motivated by some democratically agreed goal, a regulation that says we must impose this, we are going to ban this. And there's still a really important role for competition policy and competition authorities there in ensuring that any policy implemented in that way to achieve an agreed goal is the least distortive to competition, keeps level playing fields. But in that, we're sort of essentially not placing the goal of a competitive market above that of the agreed sustainability goal. And that's been predetermined by the democratic process, the government deciding what the roles are. And we've already heard one that's definitely live, certainly in Europe at the moment, the banning of sales of petrol vehicles. So by removing a well-loved and valued choice from consumers and likely imposing costs on many businesses to make change, this would not be a policy that was implemented if our goal was to retain the most competitive market for vehicles or the widest choice for consumers. And in a world where we have not internalized any negative externalities, but where we have a goal to remove the reliance on carbon emitting personal transport, then the policy of banning these somewhere in the future allows time for adaptation. And then we also have complementary policies to support it by ensuring fair access and building of charging infrastructure, consumer subsidies to encourage the purchase of those vehicles, again, in the absence of a carbon tax, which would naturally drive people towards no pun intended, drive people towards the uptake of non-fossil fuel vehicles. So all of these things means ensuring that a competitive outcome is supported on the narrow set of choices that have been determined to be appropriate. So that, you know, competition is a key part of that, but it's not actually being driven necessarily by the competitive market. But then if we think instead about where we have companies actually bringing forward their own policy, then the political, because we know and we've heard that the political challenges of implementing costly policy means that actually harnessing the benefits of commercial propositions has many advantages. So then we have to answer the question, if we look at it, is it indeed going to save the planet, or will it potentially be greenwashing? And that question is not actually straightforward, and European businesses and competition authorities are exploring it currently. And it's an important part of the guidance to be thinking about what is the rationale for the agreements when assessing them. Now, you know, there's well-known economic research here in Europe spearheaded by Martin Peter Schinkel, that's shown that where there is even some willingness to pay by consumers for a green product, despite the risks of first mover disadvantage, under certain assumptions, a competent competition authority is better off preventing almost any coordination, since that coordination will result most likely under that modeling in sales of more expensive and less green products than if competition is enforced and coordination is prevented. So without going into all the details on that, where does that come from? Where does that prediction come from? Well, it's based on standard cartel logic, which we all know, and is where the skepticism that comes from looking at these agreements comes from. So by allowing businesses to coordinate, and then their incentive can be to make choices that benefit them by restricting output, restricting investment, and increasing profits. And that seems to lead to the unattractive conclusion that all industry-led coordination is greenwashing, which does not seem right, as we've heard today from all the things that are going on in the real world. So what is the answer? And we need, and this is drawn from the work we've done on when you give the green light to green agreements. And so it's then about where are the spillovers? Where are the positive reinforcement effects for businesses from that coordination? And then in those situations, allowing firms to coordinate their sustainability efforts leads to higher overall effort levels, and squares that circle to say that there is a role for these cooperation agreements where we can see those positive reinforcement effects. So one obvious example is the benefits that come from coordinating on large ex-ante investments to support a green product. Wolf has flagged one of those examples. It's one which we worked on with Shell and Total in ensuring the joint investment and marketing of infrastructure to support carbon capture storage in the depleted North Sea gas fields and getting exemption for that under Article 101. Neither party would undertake the investment on their own, given the capacity and size of the investment, but a shared pipeline and other infrastructure made sense. And it was an essential requirement to make it work that there was an agreement on joint marketing for the first 20% of capacity and then competition above that. The authority has given that informal guidance. They did discuss the fair share assessment on all of that, but concluded that the environmental benefits to all consumers in the society as a whole would obviously offset any potential consumer harm there. So that's sort of a relatively standard spillover or externality benefit that comes from coordination for very large investments that any single firm can't do. But what other, some of the other rationales for coordination perhaps can be more challenging, where they relate to businesses having longer term or broader sustainability goals, perhaps driven by shareholder activism, other types of ESG considerations, and where there's a need, the first mover disadvantage kicks in, where you need to avoid the free riding of others on the investments required to promote a sustainable product and to educate consumers, and the short-term dominant strategy of others is to free ride on that. And we've heard the example of shrinking packaging as one of those examples where consumers don't understand and you end up in a negative, a vicious circle, and it doesn't happen. So the draft guidelines we've seen in Europe show the Commission remains skeptical of motivations around this. And this thing of how does a business really genuinely, or group of businesses, show that it's not being driven by short-termist profitability and ways of reducing competition. And I think there is work to be done to build those commitment strategies and building the discussion about what those benefits are, and showing that overall they are aligned with showing that there are these spillover benefits from doing these things together. So finally, just touching briefly on the quantitative analysis, and we can pick this up in discussion. We've heard about the need to think about fair share and the fact that guidance is increasingly broadening to include what's known as non-use value and consumers outside the immediately affected group. And the evidence base on this is still being developed. And it's certainly true that the current experience with measuring and quantifying these types of collective benefits does remain scarce. However, there is a lot of examples in other areas, in environmental economics and science, where these things have been done. And as we've already heard, the polluter pays principle can help here. We already have that idea of thinking of, okay, well, we can understand those negative externalities, quantify them. But we do, when we're thinking about fair share, the advantage of internalizing an externality through a tax means that it is the government who collects that tax revenue and can potentially redistribute it. So one of the things that competition authorities are thinking about in that fair share, and that's why I think we do need to engage with it very meaningfully, is, okay, if consumers are paying more and a certain group of consumers are paying more, then is it enough to say it's fine that that money goes to the businesses or whomever, rather than to the state through a carbon tax, which can then be redistributed? Or is that not really being a fair share of the costs of implementing these sustainable outcomes? So there's lots to say on all of this, but I'll stop there and hand back to you.
No, thank you very much, Helen. I'm struck at how, in many instances, our jurisdictions do not want to use the taxes. We don't do it. I mean, in Dirk's case with the SUVs, you can make people who buy the bigger car pay a lot to drive that car. We don't want to do that. In some ways, you know, we could solve the pesticide problem that Wolf was describing by having adequate enforcement of the given restrictions, but we don't do that. I mean, it's fascinating to me how much we're basically indirectly pushing the issue off onto private decision makers and saying, you fix it. Yeah, there's you backstop this, which is why I think in some ways we see the urgency that a number of private operators feel to come up with an answer, because the first best solution is one that we're not willing to pursue. Indirectly, we're asking others. Dominique, you don't have to speak for all of the U.S. experience here, but to provide a perspective of an advisor within a major U.S. enterprise, your own thoughts about what firms are talking about doing and where the legal framework arguably creates a good deal of apprehension about how to proceed. Dominique, please.
Yeah, sure. So I actually ended up in this debate somewhat like Simon, thinking about what I could do to for sustainability. And I was actually inspired by a talk that was given by a climate activist who came and spoke at Nike, who gave us kind of three circles. And the first was, hey, well, what are you good at? What still needs to be done? And what work should you focus on? And that ended up for me being on competition law and sustainability. And there's so much work in this space that needs to be done. I applaud the efforts of the ABA to hold a discussion and hope that there's a lot more activity in this space, because we need a lot more thought leaders and we need a lot more leadership in this space. So there's just some opening remarks. So just looking at the news, we can all see that there is a groundswell of momentum, even here in the United States, to help mitigate the impact of climate change. You can see the announcement of multi-stakeholder initiatives in private industry. Peers are talking to peers, competitors are talking to competitors to get even more work done. This is essential work to drive climate action, because once you've energized your employee base to change how you make products and how you power your facilities, and you've carried those changes over to the suppliers that you partner with, reaching the next level of impact, which is the level of impact we need to halt the impact of climate change, it comes down to collaboration. I see a moment of opportunity for antitrust to create a runway to allow this level of impact to occur and to help mitigate the impact of climate change. And I think either that antitrust can create that runway, or it can be the headwinds that companies face as they try to collaborate with each other in a real way. I want to focus on when I think that runway will be needed, and so why the urgency of the moment is now, and why antitrust here in the United States should get started. I think just thinking about a comment that Dirk made, I think antitrust has been very effective very successful, perhaps too successful in the United States at flagging the dangers of competitor collaboration. The focus on price effects on consumers is perhaps coming at the expense of a balanced debate on the competitive effect of climate-related collaboration. Fear and uncertainty in competition law may get in the way of germinating potential beneficial projects, as many business clients fear the consequences of speaking to their peers. So some developments that are happening in the United States, one big one that Dirk mentioned is that the SEC has passed draft guidelines, and those guidelines may become final. Those relate to companies being required to release data on emissions, including scope 1 through 3 emissions. This is a major shift where investors, consumers, voters, lawmakers, regulators will now be able to see not only where companies think their operations will be affected by climate change, but also the impact that they themselves are having on climate change. Transparency may inspire companies in the US to get more serious on making pledges about reducing their carbon footprint. And when they make those pledges, they will take those pledges back to the meeting rooms and boardrooms of their companies, and they'll make a plan and strategize on how to meet those pledges. And that's when the realization may kick in. This is really hard. It requires a fundamental change in how we do business. It requires a fundamental change in how we make our products. It requires a fundamental change in what we make our products from. It requires a fundamental change in how we dispose of our products. It requires a fundamental change in where we make our product, in how we ship our product. And no matter how much we energize our employees or try to negotiate with our vendors, the work cannot be completed on our own. I think that for companies that have already made pledges, they have had those realizations, and that's why you see them out there asking for changes to the antitrust laws. But you will see other companies not far behind. Because as you think about it, the CEOs of today that are starting to make those pledges, and most of those pledges are based off of targets for 2030, those CEOs will be at the helm in 2030, and they're going to be thinking about whether they can meet the pledges that they make in 2030. The second point I want to make is a fear that I have for the US if it doesn't create this runway. I fear that if the US does not start to think and influence in earnest on these issues, companies will collaborate and invest in sustainability in other countries. They will meet the sustainability demands of consumers in Europe or in Japan, where there is more certainty, more clarity on how these collaborations will be treated. And the US and its consumers will be left behind. For antitrust sustainability in the US, we are at a crossroads. We can create runway or headwinds. The choice is ours. To me, the most hopeful idea in sustainability is the belief that we get to decide how the story is going to end. If we act boldly, if we step up decisively, if we connect across borders and across divides, there is no limit to what we can achieve together. And if we do that, one day we'll be able to look back and say, we always knew that we could come this far.
Yeah, thanks, Dominique. Could I ask, is the source of concern the attitude of the enforcement agencies? Because as a couple of you have mentioned, I think there's a reassessment taking place today of what the consumer interest means. That is, and maybe a broader concept of what the citizen interest is as another way of thinking about what individual citizens want. It appears to me that especially within the enforcement agencies, that's an open issue now. That's an open issue in the redesign of merger guidelines. It's an open issue in the thought about how to use prosecutorial discretion. Is that an environment that you see as favorable to a rethink here? Is the concern that whatever the public agencies do, the possibility of private lawsuits will chill the effort to do something new. Where are the policy bottlenecks right now as you see them?
In the United States?
Yeah.
Yeah, I think in the United States, you're right. They are in both those sectors. They are both in the public enforcement, like law enforcement, but then also in what could potentially lie ahead for a company in private litigation, especially given in the United States we have treble damages.
Is this a moment on the first point where, Simon's point, we need bold, robust counseling where people look at the footholds that are in the existing framework and say we're going to use them? Are we too timid at the moment in trying to use the tools that we have?
I believe that we are too timid. I think that the changes that are necessary go beyond what current competition law affords us.
Again, these
and I just to add on top of that,
please.
it's not just what it affords us; it's the creation of certainty for businesses that want to engage in this type of collaboration. Because I think without an understanding of what the risk is, it's difficult to make these types of decisions. And so, at least an understanding of what the landscape looks like, and a creation of a safer landscape is what is required to encourage this type of collaboration.
I had a point there, Bill.
Simon, I'd like to come back to you right now. Indeed, I mean, you've heard your colleagues here. Reflections on the discussion that you've heard from the others, please.
Well, I was just going to make one point following your question to Dominique there, and that way in which the legal community can help each other. And that is where it is possible, given the client confidentiality, where you can actually publicize an opinion that's being given, just as we're encouraging the competition authorities to publish and to give guidance where they can, issue a press release where they've given positive guidance. That is helpful. But law firms can also do that. And the example is that the best example that is out there that I've seen is outside the sustainability area, or sorry, outside climate change area. And that was the opinion given in relation to the Fair Wear Foundation to pay textile workers a living wage. There was an agreement to pay textile workers a living wage, as I say, and that was published. And basically the lawyers there said boldly, this is not caught by competition law. And what's more, if it were, it is not the sort of thing that the competition authorities would pick up on. I think there's more scope for us as a community to do that sort of thing.
I mean, one thing I wanted to make sure that we had some time to discuss, and we've got about a little bit over 20 minutes before the end of our time, is your thoughts about what specific types of steps need to be taken to advance the policy agenda that you've been describing. That is this a matter of more guidance from the enforcement agencies? Is it a matter of marshaling in a more complete way? And this is one of our questions: is marshaling more examples of how the inhibitions you've described get in the way of desirable products? Do we need a process to identify with greater clarity what kinds of collective efforts would be desirable and helpful to bring this into fuller view? Do we need to change the laws themselves? That is this going to require some adjustment? I mean, when I look at Article 103 and I see indispensability, I wonder if the answer there comes from the philosophy department instead of the law department or the economics department. That is, indispensability is a foreboding type of requirement. Is that a bit too dramatic? Might that be softened a bit? Your thoughts about what specific kinds of steps are needed to take things ahead? Simon, you've described one practical step we could take. What would each of you like to see happen in the framework to move things forward? What do we need to do? And I invite Wolf as well from the point of view as a public official in the agencies. What would you like to see as further steps? Simon, did you have a further thought on this? Maybe we can start at the beginning. You have further thoughts.
Yeah, well, I would make one short-term point and one longer-term, medium-term point. The short-term point, I think the ball is largely in the European Commission's court at the moment. They are due to publish their horizontal guidelines, which contains the new chapter on sustainability that some various of us have referred to. And I think Dirk put his finger on in answer to your question, on the key issue, that is the fair share of the benefits. So short term, the most important single thing is for the Commission to move on that, to move more into line with the Dutch position. And the most important aspect of that is to step back on this requirement, which is not in the law, that consumers should have full compensation rather than a fair share of the benefits, because that's tantamount to denying the polluter pays principle. That it's effectively saying the polluter, ergo those whose consumption is driving the problem, must not pay a penny, must not pay a cent. They must be fully compensated. No, they only require a fair share of the benefits. We can't expect, the Commission may not move fully to where we would like to be, but at least if they give some more wriggle room, make it clear that this is more a policy position, even if it's one we disagree with, rather than a legal impediment. So that's my short-term point. The longer-term point is for other countries throughout the world to get more engaged with this. And that's one thing, certainly at the International Chamber of Commerce, is our priority. Is so we don't want this to be a narrow, well, it's not narrow, we don't want this to be overt too much a European debate. We want other countries to engage with this, which is why I'm delighted to be speaking to an audience in the United States today.
Dirk, could I ask you to take these concerns forward? Next steps that would be helpful.
So I think in the EU we have made a step in the right direction with the new guidelines that can partly be a role model for what the US might want to consider. I think the guidelines are quite helpful in clarifying what types of behavior are not problematic in the first place. I think that's already useful because, as others have said here today, there are concerns in different industries that whatever they do may potentially violate competition laws. So clarification is already a good thing to have.
And Dirk, if I could ask on that, do the draft guidelines anticipate a further round of guidance where you provide maybe sector by sector more specific safe harbors? Is this going to necessarily be step one in a series of additional steps where authorities say, in this sector for this kind of problem, here's where we welcome collaboration? Yeah,
so that's an interesting question. I don't think that the Commission would consider this to be part, or let's say the Directorate General for Competition would consider this to be part of their mandate. But why not have them incentivize companies to engage in cooperation? And as I was trying to say, I think it's required actually to send the message out that cooperation is something that within the limits of what we have discussed is desirable. And of course, greenwashing needs to be excluded. I could talk to that, but I'll skip that topic for now. So I think it's good to have this encouragement from the Commission, but I also recognize that they need cases in order to develop guidelines and practice. That's something that's currently missing. This is why another element of EU legislation that is currently up for review, the informal guidance notice, is so relevant, because the Commission will then have a chance to specify under which conditions they are ready to provide guidance in a formal, or even, which is provided under the procedural regulation, also formal guidance for corporations, which is currently not part of the self-assessment system that we've copied and pasted from the US some 20 years ago.
You're welcome.
And I think clarification is helpful. The EU guidelines are taking the step in the right direction, also in that they provide safe harbors for behavior that may fall under 101, but may not be, it could fall under 101, but it's not appreciable and therefore doesn't lead to appreciable effects of competition. It also entails, for instance, mandatory standards. I think that needs to be further specified in the guidelines that are still in draft. But I think that is helpful to say that under certain circumstances, in certain circumstances, companies can get together and agree not only on voluntary standards as provided for in the law, but also mandatory standards. I think the meaty questions are really in the 1013 area, where we need more clarity on the fair share and versus full share question. We need more clarity on the issue of collective benefits, because otherwise we cannot internalize externalities. That is, I think, the key question. And it's politically, of course, a big step forward. And I also hear the point from Helen, for instance, that there is the question of democratic legitimacy. I think I would respond to that, well, very pragmatically. What is the alternative? Wait for regulation that is not taking place, waiting for authorities in the environmental space that are not taking action to change their minds or to have the legal powers. I think that's not really a viable alternative. And secondly, competition law has always been political to a certain extent, less so than other areas of law. But when you look at the evolution of competition laws, especially in the US, but also in Europe over the last decades, of course, there have been a shift of changes of paradigms over the past. In the EU, for instance, 20 years ago, the types of collaboration that we are advocating for now were approved by the Commission in a famous case around washing machines and their outsourcing or outphasing, should they not be environmentally friendly, where the Commission simply said, this is beneficial for the environment and serves the treaty objective of environmental protection. Therefore, it's admissible even if it leads to cost increases. And it has not been an isolated case. So competition policy is a moving target to a certain extent. I think it should remain within certain guardrails. But the interpretation of the law that Simon and I and others have been putting forward, I think, would be warranted. It's more a question of choice. Are we ready to make this transition? It's not a matter of, does the law enable us to read the law differently than we have been maybe in the last 10 years or elsewhere, even for a longer period of time.
Dirk, one of the interesting questions in the chat, again, focuses on developing an appreciation for how serious the inhibitions are. Subject to the sensitivity of discussing openly matters that might be considered in the House right now, is there some benefit in having a broader public discussion of the specific scenarios in which cooperation of the kind you mentioned before in your individual comments, those that Dominique mentioned, is there some benefit in having a broader public discussion convened in some forum about how the collaboration could make a difference, including some of the examples that Wolf gave?
Yeah, I think, Bill, in my mind, that issue is that a lot of these issues pertain to supply chain. And I think that's an area of antitrust that's not well understood. And so in my mind, it actually a further understanding of the antitrust bar in the issues that companies face in their supply chain, in a diverse supply chain that they don't necessarily have a lot of control over, is worth having a deeper dive in. But when I talked about, right, like bringing the pledge back to the meeting room and then thinking about, okay, we have to fundamentally change how we make our product, right? Because that really goes to the climate pledge. Understanding that, I think, would pay big dividends for this debate, especially in the United States.
I mean, I suspect we could have I would see the benefit of a public discussion just about transportation, aviation in particular, sustainable fuels, materials, scheduling, capacity, any number of questions there. Because in my own interaction with agency officials and in seeing some of the comments in the chat, one question that comes out is, well, where would more collaboration make a difference? Where's the need? Or what's being scared off now that's not happening? I think a broader discussion of that would be informative along the lines that you've all suggested. Wolf, but if I could ask you, if you want to take the discussion ahead, if you want to take policy development ahead, and you've already pointed to some paths, the importance of dealing with dealing with the development of the new guidelines, the fuller revelation of activity of what agencies are doing. Additional steps you would like to see taken to move policy development ahead? The view button.
Sorry. Just a few points on the fair share discussion. I think the European Commission needs to consider what the European Court of Justice has taken as a position, which is that appreciable objective advantage and not full compensation is what is required. So we actually have case law already that's going much further in the right direction than the Commission is going. And that would be very helpful if they would recognize that. I think the European Commission should set up a permanent European competition network working group on sustainability that meets on a regular basis, just as we have for other sectors. I was part of one for pharmaceuticals, for example. And I think the idea of guidance is very important. And I think the Commission is actively looking for a good case to make a formal finding of non-applicability, what Dirk was referring to. So I think they're already thinking along those lines. As far as my own authority is concerned, there are a couple of things worth mentioning. Our chief economist team is working on a note on quantification that I think would be useful, and I hope we will be able to publish. And greenwashing is another area that we're active in because we also have a consumer branch. And I think if you're going to have an active competition policy in this area, you also need to have an active policy on greenwashing and consumer protection at the same time. And just as a final note, I think what we should try and do until the Commission comes out with its final view is to develop our informal guidance practice to push the boat out further if we can.
And of course, you're well situated at the SAM to bring the consumer protection perspective to bear on all these issues. That's part of what you do as well.
Yes, and it is still surprisingly difficult to agree with our colleagues in the consumer department. So we have to start by talking to our direct colleagues, but it is the way forward, I do believe.
If you could mention quickly, what is the philosophical or analytical tension that you see arise without telling us too much about what's going on inside the House? What's the policy rub here?
On the consumer side, they're much more concerned about the consumer protection, and they're much more skeptical about the claims that are being made and about the need for agreements for those. So there is some tension within the House on that issue.
I have seen that movie before, Wolf. We can talk about it separately someday. Helen, there have been a couple of comments in the chat as well, and if I could ask you just the general question, what do we need to go ahead? But the question of how we'll know it's working. That is, how do we assess effects of individual measures? If I stood back and said, sounds right, how do I measure actual outcomes?
So in terms of what areas?
Different steps that we're taking, are the adjustments we're making proportional? Is it the right fit? How do I know that if we're going on the path we've been describing, how do I know if it's a good path?
Yeah, so I think in terms of things that we can do, the point about how businesses can talk about the benefits, as was already raised, I support that on what are the benefits of the commercial cooperation and how you can link that to the sustainable goals. And I think the supply chain, cost reduction, all of these things they're almost like, they're not, I mean, no-brainer is probably the wrong word because none of this is a no-brainer, but the things which are cost reducing and sort of go with the flow, I think those things are things that we should have on the table much more. Where I think I see in the chat lots of discussion about ESG and why is that special, right? Mm-hmm. And I do think, that's the other big driver of spillover benefits now, is that it's very hard because of the collective action problem to go it alone on some of these things. It really does not make a lot of sense for just one business to try to make a difference on their own. but they can genuinely want to be committed to the environmental, social, or governance goals. And that's where the environmental goals, I think, do have a bit of a different feel, because some of those social and other goals, there may be more scope to differentiate and use competitive indicators to drive a difference. How do we know if we're succeeding? I think the elephant in the room is the costs of some of these things, the direct costs. And across the world, across the developed world, we're facing a cost of living crisis, and we see that is, the political appetite for some of these things.
Yeah. Many of you are telling me to spend more.
Exactly.
More.
A lot of these things.
I'm looking at inflation go through the roof, and I'm not happy about that.
Yeah, and so that is going to be a really tough battle of two conflicting interests in the near future. And sadly, I think the politics, or maybe even consumers, generally have perhaps overly short-term focus and put off the costs that come in the future. That in fact, it may be that businesses are the ones with the longest time frame. It may be boards of companies who are thinking, as someone mentioned, look, I'm going to be the CEO in 8 years, 10 years time, and I'm going to be called to account on these things. Did we meet the targets? What has happened? Which is a bit of a sad state of affairs when one should be able to rely on the politicians there.
Well, and so, I think of how many agencies today are being boiled in petrol because the price is going up. Do we really want petrol prices to go down?
Yeah.
A lot.
Yeah.
Given what that does to consumption.
Yeah.
The larger effects. Dominique, fellow North American, if we want to bring the discussion forward here, informed in so many useful ways by what the panel has said, what do we do in the US next?
So I would first encourage everyone who's attended our panel discussion and hope that they've been inspired and moved and wanted to contribute to this debate. And this is an area that we need thought leadership in. We need big thinkers. So I would encourage everyone to join this, to think about these issues, think about how we can encourage private industry to collaborate more, because I think private industry is the unlock here when it comes to climate change. Now, what we can also do beyond inspiring the bar is to get the ABA to take this up as a real issue in the form of a task force or a section. I think that the ABA should be taking this up as an issue, and then the agencies, both DOJ and FTC, should be focusing on either workshops or something to fetter out what are the issues and how they can issue some guidance here, so that we can start encouraging this type of collaboration here in the United States.
Several of you have said, this is a moment in the US in public policy where there's a rethink of what the consumer interest is. What does it encompass? Is this an opportunity to bring that directly into the debate here? Two concluding comments. If I could turn to Dirk first, and then to Simon to close things up for us. Dirk?
In 30 seconds, so that Simon gets the remainder of the minute that we have. I was thinking about your question, Bill, how we can make this work. And I think the legal issues are something that authorities need to deal with when they get the cases. I think there's a big debate, at least in Europe and now also increasingly in the US, around competition law and does it provide leeway for cooperation. But interestingly, there's not so much a debate, at least as far as I know, in the public about the necessity of cooperation to drive climate change protection and to combat climate change. So I think people in this group may also think about how can we bring this issue into the broader public, and to have companies and maybe also politicians think about how cooperation can be part of the solution. And maybe somebody with this, like you, Bill, with the stature of yours, if you published like a op-ed in the New York Times on this topic, I think that could resonate with a much broader audience. So I think this is the kind of topic that maybe the antitrust community needs to take into the broader public, and that may also then be a big contribution that we can make within our very limited remit to make a contribution to fighting climate change.
No, thank you, Dirk. Simon, you inspired this in many ways. You got us started. Some closing thoughts, please.
Just 2 points, picking up on to the best I can on several points in the chat. One, we're not looking, I don't know of anybody looking for a carve out for ESG. I considered advocating for a block exemption for sustainability agreements under EU law and decided that wasn't appropriate. What we are looking at is for the proper application of the exemption provisions, and to the extent that one is singling out climate change, it's because that is an existential threat. It is the only existential. It's the existential threat amongst all these issues. The other issues are equally important. Are also important, and they should be analysed and assessed on their own merits. But we shouldn't let any difficulties in applying competition law to agreements concerning workers or whatever it may be undermine the fundamental need to deal with the climate change crisis. And the second point, which is in the chat there, which is something which I'm pleased to see we've avoided a discussion of, and that is consumer welfare. 2 points there. Under EU law, consumer welfare is not in EU law. It's not in the treaties. It's never been endorsed by the courts. And to the extent that but if it were, it could be an appropriate standard. And I'm well aware it's been endorsed to the courts of other states. Consumer welfare is not just about profit or fortune. Just a basic looking at the dictionary tells you that it's about health, happiness, and the future of people. It's equally capable of encompassing having enough food to eat, producing products using fewer resources, and having clean air to breathe, which is what we're talking about when we're talking about fighting climate change.
Yeah, Simon, if I were to look into that wishing well of consumer welfare, I'd be happy to live with it. I could channel you and others and say, what do consumers want? They want to live. They want to breathe.
Go back 70 years, we could have that in our law, but we shouldn't be talking about it particularly because it's not in our law.
Though I guess as a closing thought, maybe a bit gloomy, and I see, comment by one of our attendees as well, is we have a terrible political science problem in many instances where there's some evident paths that arguably ought to be taken. When it comes to energy, we want abundant supplies. We want it to be cheap. We want it to be clean, and we want it to be located far away from us so we can't see it. We give a lot of contradictory impulses to our elected officials. How we develop, as many of you said, an awareness of the gravity of the problem, the need for solutions. But I do like the way, and I fear this is, if you say this is an academic's indulgence, so be it, but the possibilities for convening events on a regular basis that draw these perspectives into full relief, that bring in the other regulators who feel hamstrung or limited in what they can do, to draw the benefit of the experience that Wolf has spoken about, and that's so important. To bring our multidisciplinary team, our economists, our lawyers, our political scientists, our environmental scientists, and others to bear, and indeed to have the benefit of what Dirk and Dominique have been telling us about what firms want to do, and have a fuller discussion of that. I'd like to think that might make us smarter about what the path ahead might be. Let me again express my enormous gratitude to all of you. To Simon, to Wolf, to Helen, to Dirk, to Dominique, for bringing this discussion from Europe to the US in an enormously informative way. Further thanks to our great team at the ABA, Rebecca, Medina, the whole team that puts this together. The only people who think it's easy to do have never done one. Thank you for making this work for all of us. To our advisory group that Meg Guerin-Calvert has assembled, who gave us lots of good ideas. To our participants who had so many thoughtful things to add, and I hope we've been able to fold in some of their questions to all of you. And I look forward, I do hope that there's an opportunity to take this ahead in exactly the ways you've discussed. And thank you for helping us do exactly what Fiona had in mind when she put this together, to have a responsible adult conversation about an extremely important set of issues. Good day to all of you, and our gratitude. Thank you.